Welcome to the dojo, fam. We had to leave Mr. Neil Schwabe down there in Coconut Grove because of spring break, and you know how Miami wants to act, right? We came back to the mean streets of Windermere where, the craziest thing that happens is, one of my drunk neighbors kind of wanders out, and starts talking gossip, but you ain't hear that from me, you know what I'm saying? You know what I'm saying? Nah, I got a boring block, man. I'm like the only loudmouth on my block, so... Anyway, look, what we want to do right here is in the previous section, we talked about types of policies, right? We went through the disability income, medical expense. We just went through the types of policies worth 16%. In this section here, this is the provisions. These are the things that the policy and the insurer must provide us, okay? These are the riders, the things that we can add to the policy to enhance them, right? Just thinking about like a rider. If we're going to talk about provisions, provide, then riders. Think about that person riding shotgun. Like right here, I got my millennial. If I got my millennial in the car, I know I'm paying for lunch, right? So remember, riders cost you extra, right? Because you're adding something to it. Anyway, let's stop messing with my millennial over here, my digital, and give a shout out, right? Instagram, what is it? I am David to you. Digital, audio, video, I deliver to you. So if any of you guys need any kind of transcripts of the class, anything like that, holler at David. All right, but now, let's see. Now that I wasted a minute and 49 seconds, I'm on chapter 22.1. NAIC Model Health Insurance Policy Provisions. NAIC, who is that? National Association of Insurance Commissioners. Who is the insurance commissioner? That is head of the Office of Insurance Regulations. How did he get his job? Was he elected? No. The only person that's elected is the CFO. The CFO is a member of the commission along with the governor, the attorney general, the commissioner of agriculture, and they're all members of the commission. They appointed the commissioner to do what? Oversee insurers, because the DFS and the CFO, look at me dropping my mad acronyms, right? Chief Financial Officer, he is head of the Department of Financial Services. Easiest way to think about that is that he's elected of people, got to make poo-poo for dada, you know what I mean? He's got to make me happy, he's got to make you happy. We elected him. That's why the CFO always goes with things like customer service investigations, fire, arson investigations, things like that, unclaimed property. All that stuff goes to the CFO. Why? Because those things pertain directly to us. NAIC commissioner, he oversees the, and by the way, David, did you know we just got a new insurance commissioner in Florida? This is like, we're like in the middle of March, right? Spring break. I don't know who he is yet. Actually, you know what? I got to just maybe double check that because I don't want to, it might be a she. I don't know. I don't know who it is. Anyway, the reason that's important is because remember, the insurance commissioner has power over the insurers. And the reason for their participation in the Office of Insurance Regulation and their participation in the National Committee, right? The National Association of Insurance Commissioners is standardization. So just remember on the back of your book, that long-winded thing that should only be used for torturing people, right? Like, the book's terrible. NAIC didn't write that book, okay? That's all NAIFA, National Association of Insurance and Financial Advisors. I bet you it was the financial advisors who put all the stuffy language in there. So let's go into chapter 22.1. That's on page 352. And so you got the NAIC. I don't need you to highlight anything in that first section, all right? But if you go down a little bit towards the middle of that page, let's check out this 22.1.1, 12 mandatory policy provisions. Yo, let's stop right there. Mandatory. That type of language is always something that the insurer better do for you. You know why? Because think about this, man. I come to you, I'm your agent, Am I allowed to come into your house and identify anything that's mandatory for you to do? Get out of here, man. There's nothing that, as consumers, there's nothing that's mandatory. So these 12 mandatory provisions that provide what? Policyholder rights. So let's look at this first one. This first one, entire contract. Okay? Well, entire means the whole thing, right? Entire. Contract. What's going to be a contract? That's your policy. What this right here is saying, what I want you to do is, in the first line, I want you to highlight the bold of entire contract. And then it basically let's see, skip a line, dead center of the middle, nothing outside of the contract. And then skip a line down, can be considered part of the contract. Nothing incorporated by reference. Nothing. All entire contract provision means is that if I was your agent and I identify your policy and I break out the application, you sign the application, we agree to those terms on that application, once that application leaves you, the insurer can't change anything on it. I can't change anything on it. If I was to change something on it, that would probably be a fraudulent signature violation. It's like $75,000 and a felony of a fine. All right? Guaranteed fraud. You falsified somebody's signature. The other thing that the entire contract provision is stating is that if it's not contained, here's your contract. If it's not contained in your contract, if I verbally spoke it to you, it means nothing. All right? So entire contract provision is basically saying only the things that appear on your contract are part of your contract. Nothing stated is part of your contract. Nothing incorporated by reference. After it leaves you, nothing can be changed without your approval. Next, let's go down to this time limit on certain defenses, right? This kind of goes back to, I don't know if we've covered this yet. However, in an application, pretty much everything you say in an application is a representation. What that means is that what's a representation? It's true to the best of your ability, right? Like, I'm over here painting and I want to draw my iPad. Well, I'm not a very good painter, so it's going to look like one of Danger's pictures over there. It's a representation of the city, a representation of the Statue of Liberty. Well, that's exactly what representations are. Almost everything that you put down in an application is to the best of your knowledge. If it's untrue, the insurer's got to prove that it was material, it was relevant to you getting that policy, all right? A warranty is something that is guaranteed to be true. It's a guarantee, all right? Now, the reason I bring that up is because on the time limit of certain defenses, highlight that in the bold, and then right after that, policy is incontestable after, then jump over a little bit, enforce a certain period of time, usually 2 years. That usually nonsense really gets me, because what do I say about usually, typically, sorta, kinda? Can I test you on typically and sorta and kinda? No, I cannot, right? So notice that in the front of the book, in that S3 section where they identify the things that we have to study, they identify this time limit on certain defenses in chapter 22 and then again in chapter 29. It's not a different section. It's the same information in both chapters. It's just they to keep the excitement up, they only give you some information here and then some more information there. 2 years is a key term, a key time frame, isn't it? Usually 2 years. Incontestable periods are 2 years. Any of you guys that are going ahead and moving on and doing your 215, taking your health, life, and annuities, this right here, time limit on certain defenses. So normally you're just highlighting right here. I want you to underline incontestable. And then at the end of the second sentence, 2 years. this is all you need from there, right? Time limit on certain defenses. Remember, these are mandatory policy provisions. And what that's saying is that, if they don't identify, the mistake in your application, then they probably can't deny your claim, okay? Now, look at the bottom over here. You see fraudulent statement on a health insurance application is grounds to contest at any time. Reason being there, guys, is because our policies are guaranteed renewable, aren't they? All right. Well, that means that we're continuously lying on a new application if we're continuously renewing the policy. That's the reason. With a life insurance policy or a disability income policy or an accident policy, we're putting this policy in place, and then it's like one of those, set it and forget it type rotisserie cookers or something, right? You just set it, pay your premium, and let it go. There's no continuous interaction, but in healthcare there is, and that's why they can contest at any time. So, all right, jump over to the next page. We got top of page 353. Look, look at the, it's not that important, but at the top of the page, as a continuation on that time limit of certain defenses, in the first line, take pre-existing conditions, and then go down, skip the next line down, and in the third line, insurance company cannot deny a claim, and then next line down, after expiration of the stated contestable period, right? So that's basically just a little bit better of a clarification, right? So it's just as a time period. Once that time period lapses, forget about it. It's like statute of limitations. It's done. You can't say anything about it, right? Now, grace period. This one here, grace period's kind of a loaded. Grace periods depend on what we're talking about, right? Healthcare, under 65. Think about this. All your time frames under 65 are lower. Why do I use under 65? Because seniors, Medicare, over 65. There's a difference in the time frames between somebody like me in my prime. 49 is the new prime. I don't care what you said. All right. And a senior. Under 65, your grace period on healthcare, 10 days. 10 days, that's it. Over 65, think about your Medicare supplement, 30 days. Long-term care, 30 days. Why? It's not that we're selling it to a senior, but long-term care. Guys, we got to understand levels of care, because the highest level of care would be your skilled nursing. Your lowest level of care would be like your home health aide, and your long-term care has to provide you with the highest level and one of the lower levels. All of that stuff, your cash values, and forget about it. Like, it's the partnership with Medicare, Medicaid. There's a lot of things there for you to know in long-term care. 30 days, just like the seniors, right? When it comes to a group environment, 31. Everything in group is 31. So grace period, what I want you to highlight here is just in the first line, grace period. And then 1, 2, 3, 4, 5 lines down on the end of the sentence, all the way on the right, 10 days. Right? After that, you guys might be like, oh, it's 31 days for other policies. They didn't even tell you what other policies are. I don't want you to highlight it, but just so you know what it means, it basically means most of us are going to be paying monthly premiums, right? Occasionally, somebody might pay it quarterly, semi-annual, or annually. Those people get 31 days, right? Because they're on that set it and forget it deal. Next, I want you to look at this reinstatement. Oh, you know what? In that grace period, go to the second paragraph. You see that Affordable Care Act, ACA? Highlight that and then skip a line, third line down. 90-day grace period. Why? Because you're spending Daddy Gov's money, and Daddy Gov lets you do whatever you want. Forget about it. Oh, you can have all the benefits. Oh, you need a subsidy. No problem. Psh. Oh, you need 90 days. No, you do hear the bitterness in my voice, right? Because I don't get no Daddy Gov money, so I'm like, screw Daddy Gov. Anyway, all right, so look, let's check out this reinstatement right here. Now, this reinstatement definition kind of sucks, as do a lot of them. I think they do a better job in Chapter 29. So on reinstatement, let's take this in the first line. Second line. Reinstatement is automatic if the delinquent premium is accepted. So basically what they're saying is, if you look at it in a sequence, you have a grace period, right? Grace period is 10 days for basic medical expense and medical stuff, right? You miss it. And let's just say 15 days later, 5 days beyond my grace period, I'm like, yo, here's your money. And they say, thank you. If they accept that money, then the terms are reinstated immediately, okay? Now, look at this. Jump down into the next paragraph. 1, 2, 3 lines down, dead center. I want you to highlight this. To protect against adverse selection, losses from sickness covered only if occurs at least 10 days after reinstatement. David, do you know what they're talking about there? They reinstated the policy, and you don't have benefits for a sickness, not an accident, for a sickness for 10 days? Guys, that's a new probationary period. Write that in the sideline right there, probationary period. That's all they're doing. I don't know why they don't just throw it back in there. So basically, that's the downfall of letting your policy lapse, right? If you reinstate it, that new probationary period is actually time without you having coverage. It is possible that you didn't know you had an ailment, because what they're saying here is, in this reinstatement, to protect against adverse selection, that's saying that, look, your policy is lapsed. We're assuming, because it came right after grace period, that, like I said, oh, well, you got a 10-day grace period and you're sending your payment 15 days later. What if you sent your payment in 5 months later? That's when they have to reconsider you. That's when they take your money. There's going to be that 10-day probationary period, because you may have re-entered the policy because you had a pre-existing condition. And although 10 days isn't much, in these days here, just think about COVID, quick gestation period, right? Now, let's see, next one down. Notice of claim. On here, notice of claim, claim forms, proof of loss, time payment of claims. All of these things come together. What we're talking about here is I hurt myself, right? I go to the hospital. Does the insurance company know that I went to the hospital? See, this trips people up a little bit when it comes to the claim forms and stuff, because, what is it, 49% of Americans have their coverage through a group employer. See, the group employer insinuates a network, which meant when the employee showed up to go get health care, the people behind the desk gave you your claim forms, identified your proof of loss because you're in network. This discussion right here is really for, perhaps think about a PPO, preferred provider organization, right? Because those are independent doctors. Think about a point of service plan where you can go outside of your network or inside of a network. HMOs, you're only inside the network, so this conversation really doesn't pertain to an HMO at all. Okay? So here, with notice of claim, all they're saying is that you got hurt and your insurer does not know until you tell them. Okay? So highlight this. Notice of claim. Later on in that sentence, policy owner's obligation, next line down, to provide notification within, right on the next line down, 20 days, right? Now, you see that reasonable period? I think you should underline it, because they gave us a range there, so they're really not identifying law, I think that's, so I want you to highlight all that, but just underline that with after within, and then just highlight a reasonable period, or underline it, I mean. All right, so that's all you need there. Notice a claim, you got hurt, notify your insurer within 20 days. Now, next page, highlight the headline, claim forms. First line, company's responsibility to supply a claim form. Next line down, within 15 days. This isn't hard stuff, but we do have to remember a timeline, okay? 23%, I promise you, if they identify 35 topics and you're taking approximately a 100-question test, I think 240 is 85, 23%, make sure you know you're getting at least 20 questions here on this stuff. So this time frame, you got hurt, notify them within 20 days. They have to send you a claim form within 15. Remember, this claim form is specific. Why? Because every single form that they use, every policy, every rate the insurer used has been approved by the Office of Insurance Regulation, and they have to send the client the approved form. If they fail to send you the form within 15 days, yo, grab a crayon and write it on whatever you want, okay? I don't know if that's true, but just you can send it on, you can just send them the claim in the format that you have, okay? Now, drop down to the next one, because they send you the claim form. On that form, proof of loss, okay? So all I need you to do to highlight here is highlight the top, proof of loss, and in the second line, towards the middle, the claimant has 90 days. Next line down, to submit proof of loss. And then next paragraph down, first sentence, time limit for submitting proof of loss, 1 year, next, right under that, 1 year after the company becomes liable for the loss. So basically, 1 year. Now, what's interesting here, do you see how they talk about 90 days? A year later, that's kind of insinuating maybe you couldn't provide proof of loss. Maybe it was because of a hospitalization or something like that, right? But anyway, just remember that. So they got 90 days to provide proof of loss, and your maximum time limit there is 1 year. And your key there is, why don't you grab your pen, not your highlighter, and then the next line down, or let's see, second line up from the bottom, underline the word exception. And then underneath that, does not have the legal capacity to comply. That would insinuate perhaps a cognitive disability, hospitalization, you know, maybe it's some kind of soap opera thing. Dude's got amnesia or something like that. We don't know. We don't know. We're not here to judge. All right. So next one down, time payment of claims. Now, that's what that means. Right now, what do I have? I have a notice of claim. 23 minutes. Good Lord, David, my millennial, just told me to wrap it up, B. Right? So look, time payment of claims. Highlight this, that right there, that first bold, time payment of claims, and then immediate payment of the claim after insurer receives proof of loss. And then look at this. I don't know, why don't you not highlight it and grab your pen just so you can see the contrast here? Next line down, dead center, disability income payments must be paid at least monthly. Now, highlight this. In Florida, time payment of claims, 45 days. Now, what I want you to do here is I want you to draw a line from page 54, and right there in your time payment of claims, and draw an arrow up to legal actions on 355. We'll get back to these other two, the payment of claims and autopsy, but really what's happening here is it should go from time payment of claims to legal action, because highlight this, cannot take legal action, and then second line down and until after 60 days from the time the insured submits proof of loss. And then all the way down at the end of that paragraph, dead center, must take legal action within 5 years. That 5 years, come on. How long do we have to keep our records? 5 years. Of course, you got to sue within 5 years, because in 5 years and 1 day, I could torch those records. And where's your evidence, man? So I have 60 seconds on a rundown. So what do we got? Payment of claims on the previous page. Right there at top, highlight that bold. Payment of claims. At the end of that sentence, why don't you highlight specifies how and whom claims are made. That is it. That's all we need there. Next, physical exam and autopsy. Right there at the end of that sentence, entitles a company at its own expense to make physical examinations, and then right under that, during the period of a claim. So they have a right to do an autopsy. They just got to pay for it. And then last but not least, on 355, change of beneficiary. Well, the beneficiary is who gets your benefit. You have the right to pick your beneficiary. You have the right to change your beneficiary unless that beneficiary is irrevocable or absolute. Irrevocable, let me just tell you, all right? Me and Kelly been together like Abraham Lincoln, 7 years. Man, of all the aggravation I put her through, do you think that if we split up, she's going to say, oh, yeah, you can go ahead and give that policy to this other bimbo? Hell no. Irrevocable. Irrevocable. That means once I assign her beneficiary, that's going nowhere. It is hers. Only she can change it, right? So check this. Change a beneficiary. First line, policy owner may change the beneficiary. Next line down, unless named irrevocable. That's it. That's all you need. Those are your 12 mandatory policy provisions. 27 minutes flat. Next up, part dos, where we go through the next 11 optional provisions. Mandatory, these are things they had to do for you. These were your rights. And optional, these are things they could do to you. Sounds like a date I once had. Peace.